Hello again, everybody. Welcome to another edition of Reasonable Doubt. I'm your host, Jimmy Ardoin, along, as always, with my co-host, Julio Vela. Julio, what's going on, my friend?
Staying dry, my man, staying dry.
But you didn't get a haircut again.
I'm growing the hair out.
Okay.
It's growing out. It's growing out. I'm so excited about the show tonight, though.
I know. I'm excited, too. I knew him once upon a time when he was known only as a criminal lawyer. Now, he is known as a First Amendment lawyer. Mark Bennett. Thanks for joining us, man.
Hey, thank you for having me.
Absolutely. It's great to have you on. It's going to be a great program tonight, ladies and gentlemen. We, of course, will have Mark Bennett here all night long. We don't have anybody else. You're so important. We couldn't bring anybody else. I think you can. I think you can. We will be taking questions and comments on Twitter at HCCLA_TV. Send us your questions and comments. We'll take them live right here on the air. We'll also open up the phone line starting at 8:30 p.m. 713-807-1794. That's our number. Give us a call. Mark, I want to start and kind of get into a little personal background of yours.
Okay.
Because it's...
You don't scare me, Jimmy.
I know. You've taken on bigger and better. And that's where I want to go with this, because I'm envious. I really am. Because you've cultivated you've basically remade yourself kind of as a lawyer almost, in a way, and I'm envious of it because you have found a specialty and something that you're passionate about. And every time I run into you, you're always talking about it with such great passion. And I'm like, dang, that's really cool. He's found something that he's so passionate about. And I just wonder, how did you evolve from the criminal aspect to now what I think has really become your passion and maybe your true calling?
Sure, and I still try non-First Amendment criminal cases,
yeah.
But my greater expertise, the thing that I can do that very few people know anything about, is First Amendment law. I blundered into it. I had somebody come to me who had been convicted under the online solicitation statute, and it didn't seem fair to me, because the guy had been entrapped by a perverted justice volunteer. He said, oh, she told me that she was 40 years old and we were going to play like we were teenagers. And then that part of the conversation got cut out when I went to trial, and they didn't let me testify about that. And the prosecutor said to the jury that it didn't matter. I looked at the transcript and all of this was correct. Of course, I couldn't verify that she had said that she was an adult, but there were chunks of conversation missing. And the prosecutor had said, it doesn't matter whether he believed that she was a child or not, because she said she was. Seemed unfair to me. I attacked the statute then. I lost. The reason that I lost was that we didn't do it pre-trial. So the next time one of these cases came along, I attacked it pre-trial. And we won. The trial court tossed the case out. Well, the state didn't appeal that one. So now, we've got an idea that a good judge might throw one of these cases out, but we don't have any authoritative precedent on it, right? So the next time one came along, Grant Shiner had heard about the work that I had done. He brought me in on it, and we attacked it pre-trial. The trial judge didn't hold the statute unconstitutional. We appealed it up. We appealed it up to the Court of Criminal Appeals, and we killed that one. In the course of that 5-year time, from the first time that this statute had come to my attention until we finally killed it, I learned more about First Amendment criminal law than just about anybody knows. I mean, there are not a lot of lawyers who focus closely on First Amendment criminal law. Well,
right.
Why not? Well, first of all, First Amendment stuff is very airy.
It is. I mean, any kind of constitutional-based law. I mean, it's not your first choice when you're in law school, because it's usually the most difficult to really grasp.
Right.
Especially as a young law student, where you're like, I just want to go party, have fun. I don't want to read con law cases and try and figure this out.
Right. So it's really cerebral stuff.
I mean,
it's just, and most judges don't understand it. No prosecutors understand it. Even after ex parte low, they still don't get it. They still didn't get. The prosecutor who argued the case in the Court of Criminal Appeals was still scratching her head after the opinion came down. So I like that it's very cerebral stuff that most people don't know. I developed a special expertise in it in the course of that 5 years of study, and then I started recognizing other statutes that were subject to the same sort of attack. And that's what I have been pursuing since. Okay, so the other reason that there aren't a lot of lawyers who are experts in First Amendment criminal law is that there's not a lot of money in First Amendment criminal law. right? So there are lots of lawyers who handle First Amendment cases, and they're working for the porn companies and the the clubs and
The newspapers.
Unless
or-
you get bankrolled.
and the newspapers. So they're getting bankrolled by people
Right.
who profit from the First Amendment. Well, in criminal court, the people they're just schmoes who said something online and are getting prosecuted for it. They don't have they didn't make money off of the First Amendment. And so what we've got is individuals who are fighting for their own rights, and in the course of that, they're protecting the rights of all of us, including the porn companies and the bookstores and the strip clubs.
So the idea is that the online solicitation statute was overbroad, or let me overbroad. Is that right? Am I saying-
Overbroad under the First Amendment.
And now, if I'm not mistaken, Lowe was dicta. Maloney, they applied the wrong standard, and then comes Victoric.
Okay, so
Julio, don't try and don't try.
I'm wondering.
You're doing
Stay in
great.
the
I'm
fairway,
wondering.
man. Stay in the fairway.
Well, because I still don't get it. I mean,
Okay,
shouldn't.
This is the problem. Most lawyers don't get it.
But shouldn't Lowe be where it is?
Okay, so the online solicitation of minor statute had two parts: 33.021B, which was dirty talk to a minor, and 33.021C, which was trying to solicit a minor for sex. Sort of was that. So 33.021B, Lowe held that unconstitutional. In Lowe, in dicta, which means it's not a critical part of the holding, the holding would have been the same had it been omitted, the Court of Criminal Appeals mentioned that 33.021C was constitutional.
Okay.
So since then, I looked more closely at 33.021C and concluded that it's probably not constitutional, but now we're fighting the uphill battle against the dicta in Lowe, because all of the lower courts look at that Lowe dicta and say, oh, the Court of Criminal Appeals has already said that this is constitutional, that's all there is to it. Well, that's not all there is to it, because that's dicta. If that weren't dicta, that would be.
And it was basically saying that just the act, or were they regulating the content, or they regulating the act, or just them doing it is a crime?
Are we talking about Lowe, or are we talking about Maloney, Victoric?
Well, I guess we'll start with Lowe.
B or C. Okay, so 33.021B was Lowe, and the statute regulated speech based on its content, which is big red flag. If a statute regulates speech based on its content, it's presumed to be unconstitutional.
And it shifts the burden.
Shifts the burden to the state, right? They have to show that it is constitutional, that it meets strict scrutiny. So in Ex parte Lowe, what it was sexually explicit communications with the intent to arouse or gratify. And the Court of Criminal Appeals said, well, that's a content-based restriction on speech. 33.021C, however, has two parts. It has the bulk of the statute, which would be unexceptional, which says that it's a crime to solicit a child over the internet, solicit a minor over the internet. Minor is not just a child, but also someone who represents himself to be a child. It's a crime to solicit someone over the internet with the intent to meet for sex, right?
Like How to Catch a Predator. That show.
Right. But then 33.021D says it's not a defense that you never intended to meet. Well, okay, if I solicit you to do something, but I never intend for it to happen, I'm not soliciting you to do it.
Well, how is that any different than engaging in a conversation to commit criminal activity, right? I think that was an issue, or
right. So what the Court of Criminal Appeals said in dicta in Lowe was that statute governs conduct rather than speech. It's a nonsense distinction, because content-based restrictions on conduct are forbidden just like content-based restrictions on speech. Flag burning, for example, is conduct, right? But if you forbid the burning of the flag based on the intent to communicate a message, then that's an unconstitutional statute. And the Court of Criminal Appeals has held that recently.
Because it's overbroad.
Because it's overbroad, because it forbids some protected speech. Photography is conduct, but you can't forbid photography based on the content of the photography, except for some exceptions. For example, child pornography, right?
Right.
So if the statute governs speech or communicative conduct based on its content, then it's presumed to be unconstitutional. So what the Court of Criminal Appeals screwed up on in Lowe, and I am partly to blame for this because I didn't
phrase it. Or,
I wasn't
no.
focused on that. It was dicta. It wasn't. We weren't talking about 33.02.
Well, we all got to learn somewhere, Mark. You know.
I know, and Court of Criminal Appeals is as good a place to learn what you're doing as anywhere, Jimmy. Let me tell you.
We all make mistakes.
What could possibly go wrong in the Court of Criminal Appeals?
You got to have your first one sometimes.
That's right.
Learn from your failures,
That's
right?
right.
You learn from your mistakes.
That's right. So, at any rate, the Court of Criminal Appeals said this is conduct, not a content-based restriction on speech, and all of the lower courts have agreed with that. Well, the problem is that while what they should have said, what they could have said, what they should say is that online solicitation is speech, but it's not protected speech. Okay? And then we would get to the question of whether the fact that lack of intent is not a defense adds in protected speech to what the statute is forbidding.
Right.
I don't know if I'm making this clear.
Okay. Well, then out in San Antonio, Maloney comes along.
Maloney was first Court of Appeals.
Yeah, that was
his first Court of Appeals. Interesting.
That was actually the first case, if I remember. It was 2009.
Maloney was before Lowe.
Right.
And there, what could go wrong? They applied the wrong standard. Is that?
Yes. So Maloney said that the statute forbids conduct rather than speech based on its content. It's just wrong. It's just wrong. There would be, at least it would be intellectually honest to say the statute forbids speech, but the speech is entirely unprotected speech because it is online solicitation, because it's solicitation of a crime.
It's interesting because we have, you know, the kind of the history of this thing. It all starts with online solicitation of a minor.
Right.
And then we see the improper photography statute go down in 2014.
Right.
And that was the Ex parte Thompson case.
What basis was that on? What was the?
Same thing.
Yeah.
So photography is communicative conduct. Right. So it's speech for First Amendment purposes, and the statute restricted photography based on its content. The statute said that it was a crime to take pictures of
Well, in Thompson,
people
in Thompson,
with
he
the
had
intent to
gone,
arouse or gratify sexual
right. In
desire.
Thompson, what had happened was he had gone into a water park or a public pool or something and was taking pictures of women in bikinis.
Or maybe not women.
Yeah, maybe men in mankinis. Who knows?
No, I think maybe a little younger than, we probably wouldn't call them women.
Yeah,
I think they were younger than that.
And the issue there was whether or not, you know, people who submit themselves publicly in these kind of ways, is that, you know, are you, I guess, do they surrender any protection from becoming somebody else's sexual fantasy, so to speak? And, you know, the court said that, yeah,
Was there
it kind of does. And but they upheld the ban. The interesting thing was on bathrooms.
Dicta, again, dicta. They didn't
Yeah.
have to do that, and they shouldn't have.
Right.
So now we have to fight that uphill battle against the dicta in Thompson.
Yeah, they like carved out a little exception on, what was it, bathrooms and private dressing rooms.
Well, right. So the statute had one part for places other than bathrooms and private dressing rooms, another part for bathrooms and private dressing rooms. The fact is that the First Amendment applies in bathrooms as well as out on the street. So there is no principled First Amendment reason to treat photography in a bathroom differently than photography on the street.
Yeah.
Was there a similar intent is no defense
In
language?
No.
Really?
Well, in these cases, I like to call them, because of the nature. I mean, we get them overturned, and people obviously, you know, people don't like the actions of these of these people. Again, going back to what you said, it's not exactly like these people are, you know, you're standing up for the rights of people that everybody wants to come to their defense.
Well, right.
So I said, I was explaining to somebody one time. I said, you know, it's creepy, but it's not criminal.
Well, but
It's essentially what it is.
but then again, you know, an adult should be able to do this with an adult and play talk or enjoy themselves. I mean,
All right, and that's my argument with regard to the online solicitation statute, the other part of it, the part that the Court of Criminal Appeals didn't hold unconstitutional and low. And as an aside here, the legislature then changed the statute as of September 1st, 2015. So we're only talking about cases where people committed the conduct before September 1st, 2015. As a result, we're getting a dwindling number of possible attacks on the statute, right? Because they're not charging anybody else based on conduct before that time. But the argument is that because the statute excludes as a defense the lack of intent to meet, and excludes as a defense fantasy. That is, it explicitly says it's not a defense that you were engaged in fantasy at the time of the conduct, that the statute captures age play. That is, grown-ups talking with each other, and you and me, and we say, hey, let's pretend to be 15-year-old football players. Okay, I'm the tight end, I'm the quarterback. Hey, let's mess around in the locker room.
Pitch,
after.
shot catch.
Right. Yeah, exactly.
Right.
So if I say to you, I'm 15 years old, well, I've represented myself to be 15. The statute doesn't require that you believe me. You might know that I'm 45 years old.
Wow.
And so you're committing a crime by talking, by trying to arrange a meeting with me for sex, even though you know that I'm 45 years old, because I've represented myself not to be.
Well, and didn't one of the things they talked about in Lowe was that the language is so broad that it could basically have encompassed somebody repeating sexually explicit material that they had heard from a TV show.
Sure. Sure. And
I mean, that was the most absurd. It was one of the examples, but it took it to the most absurd example, really. But it was true.
Right, and there were lots of popular culture examples in Lowe that made it into the opinion.
Yeah.
Was it Miley Cyrus?
Exactly.
It was in the opinion.
Hey, it's my party. I can do what I want. No, get in the thing, man.
I think they got jealous of, was it Posner? Which one of those federal judges dropped like Ludacris into one of their
Probably.
opinions? So I think the Court of Criminal Appeals just got jealous. They're like, we want to put some pop stars in here.
Yeah, that was Judge Cochran, who's no longer on the court, but it was a unanimous opinion. So the composition of the court has changed since then, and I've been having a lot of trouble getting any love for the First Amendment from the Court of Criminal Appeals, because in order to get into the Court of Criminal Appeals, they have to grant discretionary review, which is discretionary. So I file a petition for discretionary review. Mm-hmm. They don't have to give any reason why they're refusing it. They can just refuse it. I think it takes 4 judges to grant discretionary review. So as long as I can't find 4 judges who are so interested in the issue that they want to hear from us, they can just blow it off and let the Court of Appeals opinion stand. Now, the refusal of discretionary review is not an endorsement of the Court of Appeals opinion. It's explicitly not an endorsement of the Court of Appeals opinion. But courts of appeals look at it and say, the Court of Criminal Appeals refused PDR on Fisher. So we're going to assume that means the Court of Criminal Appeals isn't interested in it. So we're going to follow Fisher.
Was there any legislators that, what's the process? Okay, so a statute gets declared unconstitutional. What happens next? I mean, does it go away? Is it immediately amended? Or are they waiting for a session?
So in the case of the improper photography statute and the online solicitation statute, there has been a legislative session intervening. So the legislature went back and rewrote those statutes to, they think, pass constitutional muster. This is not a binding opinion, but I think probably the rewrite of the online solicitation statute made it constitutional. I think the rewrite of the improper photography statute did not solve the constitutional problems.
Okay, so
By the way, your parody account is, or your parrot account, whatever he might be, is poking fun at your forehead on Twitter right now.
All right. See?
that is not you, yes.
Proof that it is not me. However, I am not poking fun at your forehead.
And you are not tweeting right now as you sit here.
He's very good. I do not rule out that somewhere, Mark Bennett's mind is controlling some computer somewhere in the universe to text and to tweet.
Maybe there's some way to test this.
His specific tweet says, "Forehead is hilariously wrinkled."
Hey,
it's my radiator. Not wrinkled forehead. It's my radiator.
Look, tweeter, call in. We'd love to meet you and talk to you. Maybe we can have a little First Amendment showdown here.
So 2015 was kind of an interesting year in your world because, of course, you had the Rick Perry decision come down.
Right.
Which most people don't know. They threw it out on First Amendment grounds. Yeah. Well, it gets lost in this whole political...
I have no idea. How is this true?
What do you mean, how is this true?
No, how is this a First Amendment issue? I have no idea.
Again, you fall into the unwashed masses, don't you?
Well,
he was being prosecuted for speech.
Yeah.
The speech happened to be a threat to do something, but it was speech.
Interesting.
So, and had the Court of Criminal Appeals followed the courts of appeals that have said, oh, it's conduct and not speech, they could very well have said, well, threats are not speech, they're conduct. Well, of course there's speech. Now, true threats, which are threats to commit imminent physical violence to somebody or to some group, are unprotected. But otherwise, yeah, we can threaten people. The governor can threaten to veto something. There was also the as-applied challenge, which before Perry, I'd been traveling around the state talking around First Amendment stuff and saying, look, you can't raise an as-applied challenge in a pretrial writ. But that might change. The Court of Criminal Appeals, the Court of Criminal Appeals might write a Perry exception to that, and indeed they wrote a Perry exception to that, where if you are Rick Perry, named by name in the opinions, then you, rather than petitioner, then you can make an as-applied challenge. How that will apply to other people in the future is an interesting question.
Well, and it was interesting because, I mean, the speech in that case was the threat to veto the funding for the Public Integrity Unit, which has, I think they've removed it since then, but at that time it had exclusive jurisdiction in Travis County to prosecute certain types of crimes. And that was, there was a threat made that he would veto the funding for it.
Which is something that he was entitled to do.
Exactly.
He had the legal right to do it.
And that's exactly
to make the threat.
What the Court of Appeals.
He had the legal right to veto it.
That's right.
But the prosecution's argument was that he didn't have the right to try to coerce her to do something by threatening to do it. And the Court of Criminal Appeals looked at it and thought of lots of other cases where politicians say, you know, if you don't do X, then I'm going to do Y. And so that's politics. That's the way things work.
Now, one of the interesting things, of course, and you were on our show last year before the statute took effect, and that is the revenge porn statute. And I know you get your eyes on that one. You've been,
what are the issues? I know of it, but what are the issues on it?
But September 1st, Texas, the Texas revenge porn statute went into effect, and the criminal revenge porn statute of this went into effect. There's kind of been, I know there's been a long-standing, you guys, I saw many wars with some ill-advised lawyers up in Dallas who went after you, because civil lawyer, what was his name? Who was going after you about revenge porn. I think he was a plaintiff's lawyer. I think he might do some criminal defense too, but he was kind of going at you. But I think he was railing on it, and
I think I'd have noticed if somebody went after me.
I know. Well, I paid attention to it. I thought it was kind of funny.
I probably noticed it at the time, but
you since
didn't
flushed
make
it.
Didn't make a great impression on me.
But talk a little bit about what you see as the biggest issue with the revenge porn statute.
Sure, creepy but not criminal, I think is a good way to put it, Jimmy. The conduct is abhorrent. Right, you take the images that you made with somebody else, or that they gave to you in confidence, and you share them with the world because you're pissed off at them. That's the revenge and revenge porn. The problem, however, is that it's speech. It's a content-based restriction on speech. That is, images, right? And so it's presumptively unconstitutional, and the state has the burden of showing that it's constitutional. Well, constitutional restrictions on speech restrict unprotected speech. Child pornography, defamation, true threats, and so forth. There is no category of unprotected speech into which revenge porn falls. Nude pictures are not unprotected speech. Pictures of people having sex are not unprotected speech. Pictures that are shared non-consensually are not unprotected speech. Pictures that are shared with the intent to harm, or speech with the intent to harm, is not unprotected speech. There's nothing about revenge porn that makes it fall into a category of unprotected speech. And because it doesn't fall into a category of unprotected speech, it's protected speech, because all speech is protected unless it falls into a recognized historical category of unprotected speech.
Yeah.
Now, the Supreme Court could very well recognize some category of unprotected speech that includes revenge porn, but they haven't. And it's hard to imagine how they would do it without sucking in a great deal of speech that most people think should be protected.
Have you seen anybody charged yet under this? Because I haven't heard of a case.
I have a case where the person is charged with threatening. Yes, and I do have a case where the actual revenge porn. So part of the revenge porn statute is it's a crime to threaten to publish revenge porn in order to get something, which adds an extra interesting layer, because that sounds like extortion or blackmail.
Exactly.
So I'm looking at, what has the Supreme Court said about blackmail and protected speech? And I'm not finding anything. Maybe blackmail is protected speech as well, as long as it's not a true threat, a threat to commit physical violence against somebody. So yes, there are cases that are pending. I think they're both in the Fifth Court of Appeals, which is up in Dallas. I've got a lot of these going on.
Your friend, he replied to you, Julio. He said, "I'm busy soliciting minors online now that the real lawyer says it's legal to do so. Can't call in."
Hey, look, hey, okay. Let me tweet, and I can be a 15-year-old playing as an adult. Yeah, let's see. Let's test it. Go ahead and send me something, man. Let's see if you get charged.
So I mean, this guy is basically taking your Twitter photo. Mm-hmm. He's put it up, and I got to be honest, ladies and gentlemen. I really honestly thought that Mark had set up his own a separate account to troll himself. I really did. I thought you were doing it as a social experiment. I told you that before you went on the air. And so now I think it's even more funny.
Oh yeah.
That it's legitimately somebody coming after you.
Yeah, it's a tribute. I compared him to a Milli Vanilli tribute band.
Yeah, he is. I mean, imitation is the most sincere form of flattery, isn't it?
Yes, and he or she really does a great job of it. I think it's amusing to me and a little bit odd. I'm very wary of flattery, but it's fun. It's been fun to watch. When it first came up, I commented, well, that's it shows promise. Let's see what the person can do with it, and it's gone some good places.
It really has. So what are some of the other?
That's at Free Speech Dog.
What? At Free Speech Dog. That's right. That's his Twitter handle, or her. Who knows? What are some of the other statutes that you're currently either challenging or you think need to be challenged?
So there is a statute in Georgia, which is the equivalent of the online solicitation statute that I killed here. Mm-hmm. We argued that in February. We should get an opinion in the next 6 weeks because they apparently have until July 15th. Supreme Court of Georgia.
And you got some rousing support from the locals in Georgia, from what I could tell.
I got some good support from the locals in Georgia. I did. But some people just didn't like. Some people didn't like my argument.
They're more conservative in Georgia than they are here.
Of course. It's on. And I made the conservative argument, which was that when the country was founded, you could have sex with children. That's the age of consent.
I watched it online. It was
the age
an
of
excellent
consent.
argument.
Yeah, it's on YouTube. The age of consent didn't become 17 until very recently, like certainly within the last 100 years, which is given the inherent originalism behind First Amendment law as it is now, which is we look at whether historically this was an exception to the protection of free speech. I think it's a sound argument, and it's something that I hadn't thought of before I went out to Georgia to argue it. Mm-hmm. So I've got that. There's a statute in Georgia that forbids cussing out a school bus driver, berating a school bus driver, and so I'm going out there in July to argue that before the Georgia Supreme Court. There's the online impersonation statute in Texas, and the fraudulent use of identifying information statute in Texas. The online impersonation, we've got 2 cases where the trial courts granted relief and the state appealed. So in Waco and in Houston, we've got states appeals pending, and it's a nice position to be in, to be defending the trial court's judgment rather than attacking it.
Yeah.
The problem with that is that while it's called online impersonation, the statute forbids any use of somebody's name online with the intent to harm them. And using somebody's name is not just impersonation. If Free Speech Dog, if he used my name, Mark W. Bennett, and he misspells it, if he spelled it correctly with the intent to harm me, then that would be online impersonation. In fact, he uses my photograph, right? And so if he did it with the intent to harm me, then that would be online impersonation. But here's the thing. Who decides whether he has the intent to harm me? Right?
Exactly.
I don't think he or she has the intent to harm me. But if I did, I could complain to a prosecutor about it, and that would be a felony charge. And there could be subpoenas out there to Twitter right now.
To figure out who Free Speech Dog is.
Are there any federal laws that are similar to this, to that could be challenged?
Before we go there, let me remind everybody, it is 8:30. I want to let everyone know we're opening up the phone lines. We'll take your call, 713-807-1794, and join the conversation with at Free Speech Dog here on Twitter, at HCCLA_TV. Federal laws.
Federal laws are generally tighter, but yeah, there are some that are problematic. I haven't had anybody who's come to me with asking for help attacking one, but I've looked at them and said, there might be an attack against that. They're usually better written, though. The federal laws are usually more carefully written than the state laws because somebody in the U.S. Congress knows a little bit about free speech. Nobody in the Texas legislature knows anything about free speech.
Apparently not very many in the Court of Appeals either. But that's another show.
No, not in the Court of Appeals, not in the criminal courthouse. This is really abstruse stuff, which I'm trying to simplify for everybody. Because if we have a clear understanding of how simple it really is, then the legislature will stop passing unconstitutional laws. If they want to forbid some sort of harmful speech, then they will have a better chance of writing a constitutional statute to do it. And we won't be fighting, we won't be ruining people's lives and emptying their pocketbooks over things that should never have been against the law in the first place.
We open up the phone lines and we've got a call right off the bat. Let's drop it in here. Hello, welcome to Reasonable Doubt. Thanks for calling.
Hi. I was wondering if it's illegal to say you want to overthrow the federal government, and I think that back in the 70s or 80s they made some laws saying that you can't make those kind of statements anymore.
Well, so you can't advocate the violent overthrow of the government, but just saying, hey, it might be a good idea. Or, is a patriot going to appear to take care of, to get rid of this guy if Congress won't do it on its own and he can't be impeached, is not the sort of advocacy that the Constitution allows to be forbidden. In order for the advocacy of a crime to be unprotected, it has to be advocacy of imminent commission of a crime.
And then I was wondering if you want to get involved with Al Qaeda or ISIS, does the Homeland Security kind of trump any free speech or stuff like that?
No, it doesn't. So
there's a case going on right on that.
Yep. So again, if the speech is advocating the commission of a crime or is intrinsic to the commission of the crime, then it's unprotected, right? But just saying, hey, I think Al Qaeda is a good idea would not be unprotected speech. Now, the problem is beating the rap rather than beating the ride. That is, you get charged and you have to go to court and you have to hire a lawyer, and maybe you win, maybe you don't. It's a pretty good reason not to talk even in pretend as though you think it's a good idea.
Yeah, I wouldn't advise it.
The federal case going on right now, and it comes down to whether or not this individual from Minnesota or Ohio really intended to go join Al Qaeda and participate in these things. And I don't know if the jury's out. I don't know I don't know the stage they're at. However, but it's a very interesting issue that I thought, wow, it really comes down to whether or not this guy intended or whether or not they were just talking fun.
So if I get accused of trying to solicit a crime or engage in a conspiracy, it should be a defense that I didn't mean it, that I was just kidding. But that would be an as-applied defense, saying the statute is unconstitutional as applied to me because my speech was protected, because I was just kidding around. I never really meant to join ISIS and go off to Syria.
Right. That's a great. I don't know. That's good. That's good. I don't know. I mean, I'm not going to be the test case. I mean,
let's see if we can get something working right now.
That was a great phone call.
Very good question.
Very good question. Mm-hmm. I want to get to one of the current event topics that I'd like to talk with you about this evening, and that is the first one being this PayPal founder, Peter Thiel, funding. It's come out last week, I guess. that he funded the Hulk Hogan lawsuit against Gawker.
Right.
And from what I've been able to tell, he's paid upwards of $10 million. And the interesting thing here, for those who don't recall, we kind of talked about it on this show, but Hulk Hogan, of course, went to trial against Gawker Media for posting online a sex tape where he was recorded having sex with his best friend's wife. It then got published. He sues Gawker Media and, ends up winning a $140 million judgment.
But why? Isn't that content or conduct?
Content?
Content, isn't
It's
that?
definitely content. There's no doubt about that.
Why is that not protected? Or why is that unprotected?
Right. So I think it probably is protected, and I think if it were a case in the U.S. Supreme Court, I think we would find out either that it is protected or that there is some previously unrecognized category of unprotected speech into which it falls. I think it's protected speech. The problem, however, with a civil lawsuit is that you can't make the sort of pre-trial attack on the theory of liability that you can in a criminal case. Because in a criminal case, you have a statute that forbids a certain kind of speech, and then you can go in pre-trial and say that statute is overbroad. In a civil case, you don't really have that procedural avenue to attack whatever the theory of liability is. And so by the time you get to a real decision on whether the speech was protected or not, you've already got a $140 million judgment against you, and you've got to post a bond probably to even appeal. So you've got monetary issues. I hope that they have, apparently somebody has come in to fund the
Gawker?
The defense to fund Gawker?
Yeah, and I just saw a blurb about that, but
An amicus. No, somebody was going to pay. Somebody was going to fund the amicus, not to represent Gawker, but to file a brief on behalf of those whose interests are affected by Gawker.
And the interesting thing here, and Mark,
another billionaire. I don't remember who that was.
Yeah, now it's become who has the greater war chest on this deal.
Yeah.
Well, I mean, they're publishing things about secret things about people all the time. I mean,
exactly, and that was the whole point. Thiel, the founder of PayPal, who was one of the first investors in Facebook, made a ton of money. They had written some very ugly stuff about him, outing him as gay before he ever even came out on anything. So he's apparently they've known he's had it in for them for a long time. There's a long-standing spat, but it's interesting because, Mark, you're a blogger, and you have a very popular blog, a very successful blog. You've had it for years. This goes right to the heart, and you have made no bones about calling people out for misconduct. You've made no bones about calling lawyers out for misconduct.
Judges,
prosecutors, lawyers who try to solicit you for, to sign on to illegal activity. It runs the gamut. Right. And
I hurt a lot of people's feelings.
You do.
I rustle a lot of jimmies.
But
as they say.
but hurting people's feelings, that's just comes with the territory.
So Thiel's feelings got hurt, and I'm not saying it's inappropriate for his feelings to have been hurt. I think that what Gawker did was inappropriate. It was creepy, right?
Yeah.
But again, we come to the point where we have to say, okay, that's inappropriate, and there ought to be at least social sanctions for it. But at some point, we have to draw the line on what we punish with the law, and we want to draw that line as far from the speech that we think is beneficial as possible, right? Because if we just say, okay, everything that I think is beneficial is protected, but nothing else, well, then what's to stop the next guy from saying, well, Bennett, I don't think that category of speech that you think is beneficial, I don't think that's beneficial. So if the rule is going to be only beneficial speech is protected, then, well, today I'm deciding what's beneficial. And so that speech that you'd like to engage in, that's not protected. Criticism of other lawyers, that's not civil, and it's not going to be protected. You can be sued for that. So the thing about Thiel is he basically put out a hit on Gawker, a legal hit. I'm not sure how I feel about that, except that I don't think that it should be celebrated. There are people who call themselves free speech advocates who cheer, hey, thank you, Peter, for killing Gawker, because Gawker it's a trash tabloid. But I look a little farther abroad than just the specific case. I try to look at the forest rather than just the tree. Now, particular tree got cut down. Okay, well, nobody's crying about Gawker. There are probably some people crying about Gawker. But what does that mean for the rest of free speech? If they can do this, then what else can they do?
Well, and Jeff Bezos, the CEO of Amazon, who's also a billionaire, he came out today, or was it today? Maybe a couple days ago.
Also the owner of the Washington Post, yeah?
He is, yeah. So he has a kind of a vested
Who
interest
reads
in
the
this.
Post anyway?
Well, you know.
They used to have a great comic section.
But he said, I don't think a billionaire should be able to fund a lawsuit to kill Gawker. The best defense against speech you don't like is thick skin. If you can't tolerate critics, then don't do anything new or interesting. I agree. I mean, you know, if you can't take the heat, get out of the kitchen kind of thing. Now, look, look, what Gawker did was ugly. I mean, from a social standpoint, I think there's been a lot of people who would say, look, if you're not ready to come out, you shouldn't have to be forced to come out.
Yeah.
And so what they did was they made that an issue when he wasn't ready to make it an issue. So in that regard, completely unfair.
I think ugly is a great word for it.
Right. But again, when you put yourself out there, when you are the founder of PayPal, when you are, a big time investor in Facebook, and you make a bunch of money, and unfortunately, our society is one where anybody who can, with some fingers and can open this up, can essentially get online and start writing what they want.
Sure, and
that's the beauty of our country.
That is the beauty of our country. The other side to this is that people were paying Gawker to do this. This is not something that Gawker had a billionaire backer who was putting out hits on Teal. People were buying advertising on Gawker, and people were clicking on this video. Gawker was providing the American public with what they thought they wanted. Well, if you ask them to vote on the First Amendment today, it's never going to pass. But at the same time, they're benefiting from a strong First Amendment.
Well, and the concerning thing here is now you've got, as you said, it's basically become, you can buy justice. You really can buy the ability to kill a company, in some ways. And we've seen a lot of that go on before, but never to this extent.
Right. So if I sue you one time, you've got to hire one lawyer in one court, and you file one motion for summary judgment, one slap motion, and the case gets kicked out and you get your lawyer's fees. If I sue you 100 times with 100 different plaintiffs in 100 different courts, there's no way you can defend yourself. There's no way you can defend yourself, because if I'm willing to put $100 million into attacking you, you're going to have to spend $200 million defending yourself.
Right.
So now something interesting has come up right around the same time as this Gawker suit. Have you seen WeSearcher?
I have not.
No. So WESEARCHR, it's a site where investigative research can be crowdsourced. So somebody puts up a contract on WeSearcher, says, I will pay $10,000 for information that so-and-so has committed a felony. And then other people can contribute to the bounty. And then once the bounty is made, once enough people have donated the money that the money is there in the bounty, then whoever comes up with acceptable proof that so-and-so has committed a felony gets the money.
Wow.
So right after this, after the Peter Thiel thing hit the news, on WeSearcher, somebody posted a bounty for information about Nick Denton, who is the president of Gawker, having committed a felony.
Wow.
So there's interesting stuff going on, and the First Amendment protects WeSearcher just like it protects Gawker.
Interesting. We got another phone call coming in. Let's jump over the phone lines. Hello, welcome to Reasonable Doubt.
Hey, gentlemen, how y'all doing tonight?
We're doing great. How are you?
Great, thank you.
It's been good. I hate to jump back to an earlier topic, but my friends and I were sitting watching the show.
No problem.
We were wondering why isn't the Texas drone photography statute unconstitutional?
I think it is, or was it?
No, this is drone photography.
Oh, the drone.
Yeah.
To tell you the truth, I haven't taken a look at it, but I suspect that it's not a content-based restriction, that it's a manner or means restriction on speech. Place, manner, means. So the standard for that is considerably more relaxed than a content-based restriction, but I'll take a look at it.
Is it the fact that the method or the way that it's being done?
Right. So rather than saying it's a crime to take pictures of people, it's saying it's a crime to take pictures with a drone. I'd have to take a look at it, and what I really need is somebody who is willing to get arrested, charged for violating the statute. Because in Texas, without actually having a defendant who is charged, there's not a whole lot we can do to challenge the statute.
Yeah, you got to find a guinea pig.
You got to find a guinea pig, and it's got to be somebody dedicated. The hero of the Lowe case was not me; it was Mr. Lowe, who was willing to put the time, the energy, and the money into making the world a better place by freeing us to talk dirty to children.
Well, from not screwing up the First Amendment.
Yeah, right.
I mean, that's what because it makes a great point that, adults should be able to engage and do whatever they want to do. If they want to have dirty fantasies or do it or talk dirty or do whatever they want to do, they shouldn't be, the net shouldn't be so wide that you could be an adult and engaging in constitutional free speech shouldn't run the risk of that being a problem.
At Free Speech Dog, even though he or she can't call in, is very busy on the Twitter tonight.
Oh yeah.
Wants to know why there are no women on the show.
Yeah.
We've tried to address that issue. We really have, and we're searching for searching for female
for a
guests
doctor to
come
help
on.
JV transition.
That's funny. It's only
he's growing the hair. He's growing the hair out.
I'm growing it out, man. I'm growing it out.
Have you considered super glue?
No,
Just
I've been in touch
shave
with
the Adam's apple
Caitlyn
next.
Jenner. Yeah, him and I, or her and I, are talking.
Free Speech Dog also wants to know why don't any of you have that annoying Texas drawl?
Well, I'm Mexican.
Like the judge in the Trump University.
Oh, God, yeah.
You're a coon ass.
I am a coon ass by origin, and so I lost that and never gained this. So.
and I'm a cosmopolitan.
There it is.
That
there
answers
it
your
is.
question. Okay,
Let's put on the drawl for him.
Yeah,
all
let's
right?
put on the drawl.
We can do it.
Next topic I want to get to is this Nevada judge. So this judge out in Las Vegas,
Right.
he handcuffs this public defender in court, and obviously there are always two sides to every story. She gets a little mouthy with him. He gets a little mouthy back, and of course he's the one in the black robe, so guess who wins that battle?
Right.
Puts her in handcuffs, I think, puts her over in the jury box, makes her wait over there while he goes ahead and sentences her client without her by her side. Two wrongs don't make a right in this, in my opinion. And there's been a lot of people coming to her defense and saying, judge should never do that, but your friend, Scott Greenfield, up in New York, who writes another great blog that I read a lot, he basically said, look.
He writes like 6 different blogs.
I know.
He is prolific.
He is.
The man is prolific.
I don't know how he finds time to practice law, but.
He has longer days than we have because he's old. He doesn't need much sleep.
But I mean, he made a good point, and that is, I'm not going to be scared to call this woman out. I don't feel like I need to necessarily go bat for our team all the time, especially when they're in the wrong on this.
Right.
Now, yeah, what the judge did was bad, but she could have learned a better way to handle this.
Right. So if you're a lawyer defending a client, you have to be sensitive to the terrain, right?
Yeah.
You can't keep pushing when it's not going to do your client any good. And once the judge handcuffs you, you're probably long past the point of doing your client any good. So right. I didn't see video, I didn't read a transcript, but frankly, the act of handcuffing a lawyer is a weak act by a weak judge.
It is.
I don't have any endorsement of that, and if this happened on my watch, I'd be up there in a heartbeat getting her out of handcuffs, because that's what I do with the strike force here in Harris County.
Mm-hmm. And we'll get to that in a moment.
But our primary responsibility is not to our egos as lawyers. We're not entitled to feel like we're being heard. We have to defend our clients, and sometimes defending our clients means kissing a little judicial ass.
And checking your ego at the door.
and checking your ego at the door, which is a nicer way of saying what I just said and immediately regret it.
What astonishes me is, wasn't he the power of some of these JPs or the jurisdiction?
Justice of the peace, right?
Yeah.
Yeah.
I'm sitting there like, what?
Yeah.
Yeah.
Yeah, you can put somebody in handcuffs?
That's,
Are you even a lawyer?
yeah, that's what I'm thinking.
Their court system might work a little different out in Nevada.
I'll bet a Texas JP could put you in
Oh, he
handcuffs
probably-
if you mouth off to him. He could probably take you out back and have you shot.
That's probably true.
Probably do it himself.
And probably in some of these more rural counties, it might happen.
That's right. He's also the sheriff and the
Yeah.
DA.
He's a one-stop shop. He may not even be a lawyer.
Yeah, he may not even be a lawyer.
Doesn't need to be a lawyer.
Doesn't have to be.
Roy Bean didn't need to be a lawyer. He just needed a law book.
Did
That's
you see
right.
the picture of the judge?
The
The guy got one eye looking this way and the other this way. I hate to go there, but it's
I
like,
mean, look, you didn't have to go there.
I don't want.
He didn't have to. He
Hey,
already,
you
he
know
already,
what? This
he
is
already
per-
showed what he is by handcuffing a lawyer.
It's protected speech here. It's
Amen.
protected speech.
Just stay the hell out of Nevada.
Yeah,
is my
no, I'm not
advice.
going to Nevada
I
anytime.
want to go back to what you mentioned before about being part of the strike force for HCCLA, which of course the Harris County Criminal Lawyers Association is the sponsor of our show, and you do a wonderful job always coming to the aid of other lawyers when they need it. You're always there if somebody needs to make a record, you're there to witness it. And you wrote recently on your blog about an incident that happened, was it last year or 2 years ago? Kind of similar to this,
It
but
was
not.
2014.
Was it?
It was a while back.
So kind of give us the background, because I wasn't there. I don't know about it, but it was similar without the handcuffs.
So one of our members got taken into custody by a Harris County district judge, felony court judge, because she didn't jump fast enough when the judge said jump. And I got the message, and I came up there, and some other lawyers had already appeared, and I talked to the judge and said, Judge, what's going on? Why is she in custody? Well, I want her to apologize. And I went back to the lawyer, and I said, she wants you to apologize. I think you should just apologize, make this go away. And another of the lawyers there, Tiaiva Bell, who with the PD's office, said, no, you are not going to do that. You should not do that because you were in the right and you should not have to apologize to this judge. And the lawyer said, she's right, and refused to apologize. And I was really proud of our group at that time because I was being the counselor and saying, look, let's just make this go away easily. Well, I wasn't considering the price of an apology. Because in this situation where the judge has a history of mistreating people, an apology would have fed the judge, and it wouldn't have been appropriate. So she said no, and I went back and said she's not apologizing, and the judge said she can just leave. So let her out of custody. Well, the lawyer comes, well, it's not good enough for the lawyer. She files a complaint with the Commission for Judicial Conduct on the judge. And the judge apparently claims in the course of defending the grievance that she never took the lawyer into custody. She had taken the lawyer into custody. So some people who were witnesses write affidavits for the Commission for Judicial Conduct. Ultimately, the judge is sanctioned. She receives a private sanction for this, it's big stuff. I mean, it's not something that gets published. It's not something that gets publicized. But judges don't want even a private sanction from the Commission for Judicial Conduct. So I was in her court recently, and for a while she had been really nice to me before this event happened because of some other personal stuff. But she it suddenly was personally rude to me, and so I wrote about that. I don't think it's acceptable for judges judges need to be judges. Judges need to be Yoda-like and objective.
Well, and doesn't this really all come down to the fact that lawyers, in a sense, we have lost the professionalism part of this profession?
No.
To a large degree?
No.
You don't think so?
No. Lawyers have lost the professionalism part of this.
I find that in a lot of cases, that there has been a steady decline in the professionalism amongst colleagues to one another, whether it's the bench to the bar or across the bar. I just find that there has been overall, I think, a steady decline in just overall
I don't think
professionalism.
so. I think there are pathological cases where there are lawyers who don't have a sense of professionalism, who take it personally, lawyers and judges who take it personally, who are rude, who don't treat human beings like creatures worthy of respect. But I think it's a few pathological examples, at least in the criminal defense bar, in the criminal courthouse, I should say, rather than a widespread trend. And it may be that we're noticing it better because there are people willing to call it out now where there once were not.
That may be.
15 years ago, nobody would have written about that judge. Nobody would have filed a complaint about that judge. There would have been no strike force appearing in that judge's court. So it may be that we know more about it, that we see more of it because of the web, because we don't have to be afraid.
Well, you might be right on that. Now, you have convinced me.
Well, I mean, look at the table here. You know, JV's a really young lawyer. You're a slightly older lawyer, and I'm ancient. And you know, I don't think that there's a difference in professionalism from one end of the table to the other. I think that everybody here has been brought up right to treat the client as job one, and then do the best job possible on behalf of the client.
Well, but I think there are people who, there are people who care more. I mean, both of us, we have, I don't want to say we've always done it the right way, but we've cared enough to try to learn how to do it the right way. And I just feel like I see a lot more people, and maybe it is just the fact that we learn about it more because somebody will tweet it or they'll talk about it on Facebook immediately when it happens, and you'll see it and be like, dang, not again. Of just somebody who just is either not treating someone with professional respect or really not taking the time to learn how to be a good lawyer, a decent lawyer.
Right. So young lawyers are coming out of law school with $150,000 in law school debt or more, and in our corner of the world, they're coming out and they're trying to make a living as solos, which is a really hard thing to do. And corners get cut. And then there's a race to the bottom because, one guy advertises on his website that he has, 10 years of experience when in fact he has 3. And then somebody else sees that and says, man, I know that guy doesn't have 10 years of experience. Maybe I can find, something else that I can say about myself that will attract the clients. And then it's just boom, 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 boom. Because a lot of people are desperate.
Speaking of being professional, I want to make a correction. A couple weeks ago, I said Fox Curl challenged the protective Brady notices. In other words, the DA is now filing a protective or a gag order on Brady notices of officers so that you cannot talk about any sort of issues with the cop that's been revealed to you with other defense lawyers or anything else. I said it was Fox Curl. I gave Fox Curl the credit for challenging that on First Amendment grounds in Fort Bend. It was actually Lee Cox. And so while we're on the discussion of First Amendment, apparently Lee Cox challenged the grounds, the gag order on the protective order for the Brady notice on First Amendment grounds. And I think we're wrapping up here, but
I haven't seen the gag order. Sounds like nonsense to me because they have to provide you with the Brady notice. They can't put conditions on that. They can't. You can't. If they have to constitutionally give it to you, they can't say, "Oh, you can't have this if you're going to share it with other people."
Great topic.
And on that note, we are done for tonight, ladies and gentlemen. Mark Bennett, you are going to have a treat reading your Twitter feed when you leave here.
Thanks, Jim. Thanks, JV.
Hey, it's a pleasure to have you on the show.
It's a pleasure to be here.
It was a great time.
I know I was anathema for a year or so.
No.
I was.
We love having you on. We're going to get you on again. So
we'll have a talk about history here.
That's right. That's all we have tonight, ladies and gentlemen. Tune in next week. We'll see you.